Hello everyone, welcome to the channel. This is Private Outpost and my name is Trey. Today we're going to be talking about the Admiralty and Maritime jurisdiction. We're going to be going all through that today, and so I'm going to go in a little bit hard here on this information. So I'm going to do it once in this video, and this will be the video I continue to reference as we talk about this colorable Admiralty and Maritime jurisdiction. The first thing we got to look at is the Sixth Amendment. Now, even though the Sixth Amendment of the Constitution is protected under Article 6, Section 7 of the South Dakota Constitution, the 14th Amendment's Due Process Clause compels the state court to apply the U.S. Supreme Court's interpretations of the Sixth Amendment to protect U.S. citizens. Now, your Social Security number is a U.S. citizen, and the Sixth Amendment, what applies to us is, in all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and cause of the accusation. That's what you want to know. And in all criminal prosecutions. So we're focused on criminal and civil. I'm going to be showing you how the Admiralty courts merged into the civil courts and the criminal courts. It happened in both of them. Now, most people wouldn't say that it merged, but when you look at the entire context of what happened in the federal rules of civil and criminal procedure, it merged in there. It did. Now, here's how we're going to go with this, okay? So, something you need to know is for an error to be reviewed, you have to object. You need to preserve it for the trial court. And in order for you to do an appeal, this means the defendant has to object in order for the vagueness of the judge's statutory jurisdiction. He's going to respond that way at the trial level. Now, we need to be able to object to that. And as I said, the 14th Amendment clause here, there's a due process clause in here. No state shall make or enforce any law that shall abridge the privileges and immunities of citizens of the United States. This here applies to your Social Security number. So the states cannot discriminate, which means they have to apply the U.S. Constitution to your state court. So let's talk about the federal legislative power, and then we'll talk about the state legislative power. There's two legislative powers at hand right now, and we need to cover both of them. So this research document is questioning the nature of the legislative power granted to the legislative branch under Article 3, Section 1. This is where we're at, Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. That's what we need to take from here. Now, Section 2 gives us very specific cases that apply to this judicial power. The confusion comes in here is that the inferior courts of Congress that they ordain and establish, this applies to Article 1, Section 8, Clause 9, right here. The U.S. Congress has the power to constitute tribunals inferior to the Supreme Court. Okay, so they can create their own court system. This is the U.S. District Court system or the federal court system. This is how they do it. This is how it's done through the Constitution. Article 3, Section 1 is where the judicial power was given. That's a misnomer, okay? So it's not the judicial power that was given or granted to these inferior courts. That's how they trick you. They want you to believe that. What actually is occurring here is that the judicial branch is granting a legislative power to the Congress. So this is how they got the legislative power to actually create their courts. It's not technically a judicial power. It's not an Article 3 judicial power. It's called a legislative power. This is how they got the legislative power from Article 3. That's how you're supposed to interpret this. Now, it's proven, okay? So we have a court case that actually talks about this, and it's called Marbury versus Madison, 5 U.S. 137, 1803. So the year 1803 is when this went down. Marbury versus Madison. And this is a very Very important court case. It's foundational to the understanding of separation of powers. The U.S. Supreme Court case, Marbury versus Madison, established the Supreme Court's independent role as the ultimate interpreter of the Constitution, who has the authority to declare an act of Congress unconstitutional. And they do this through something called a judicial review. This is how the appellate process works. It's a direct consequence of the separation of powers doctrine. And so what happened here was the Supreme Court decided, they've been doing Admiralty cases for like 10 years prior to this, but they decided we need to do something else with the judicial branch. And Justice Scalia talks about this, but they can declare any act of Congress unconstitutional through an appellate process called judicial review, which is granted to their courts and the appellate courts. And this was solidified in this case. All right, so this establishes the separation of powers. If it wasn't clear enough in the Constitution, this absolutely did it. Tells you it's a legislative power. Okay, so now we're going to talk about the state legislative court. The state legislative court, just as important. What you need to know about the federal is that Article 1, Clause 3 is to regulate commerce with foreign nations. This was the power given to them. They can regulate commerce across state lines. We go to Article 1, Section 8, Clause 9. Like I said, they can create tribunal courts inferior to the Supreme Court. This is where their courts come from. And then we have Article 1, Section 8, Clause 17. And this one's juicy. Congress has the power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 square miles. This is the jurisdiction. This here is the District of Columbia. Okay, so this is how we know where the jurisdiction originates from, the courts originate from, and where they're allowed to regulate commerce. They did expand this power, the commercial power here of Article 1, Section 8, Clause 3. This was expanded, but it started out right here in this district. Now, back to state legislative power. Just like the federal Article 1 tribunals are created by the U.S. Congress, and this happens under Article 1 powers, the state level magistrate courts are created by the state legislature under its state constitution legislative powers. And it's a creature of statute. That's what the state level magistrate courts are. They're administrative in nature because they do not have any pure judicial power. Okay, so we were going through the judicial power. Where is it here? Right here, Article 3. The judicial power is vested in the Supreme Court. And this becomes a legislative power in these inferior courts that Congress makes. So this happens on the state level just like the federal level. Separation of powers is happening on both levels. Now, this is because the magistrate courts, they're administrative because they do not have pure judicial power to conduct a judicial review. This should be obvious when you think of the appellate courts, right? The appellate courts come after the district courts, or on state level, you have your magistrate, lower level courts, and then you can appeal their decision. The only reason you can appeal their decision is because it's not final. That first court you get thrown into, that decision is not final, even if you have a trial, because you can appeal. Under certain conditions, you can appeal, but this is why you can appeal. It's because this judicial power is not given to those inferior courts. It's a legislative power. So you can kind of see it now, right? So now we're going to talk about Article 3, Section 2. Okay? What this says is the judicial power shall extend to all cases in law and equity. And then down here it does say to all cases of Admiralty and Maritime jurisdiction. That's what we're going to pay attention to. There's a lot of stuff here. It's talking about different types of cases. Okay, I'm going to try to make this as clear as possible so we know what we're dealing with. these are the three types of jurisdictions. We have common law, which is going to be in law here, and then we have equity. Before you disagree, hear me out. And to all cases of admiralty and maritime jurisdiction. I'm saying there's three different types of jurisdictions listed here, and I'm going to tell you how this manifests. So in law, right here, we're going to focus just on this part and equity. What do these two things describe in this paragraph? So the common law jurisdiction of remedy, and then you have the equitable jurisdiction of remedy. These are two overarching frameworks for the type of relief and legal procedure that apply to the case. Once that case properly falls within one of the 9 enumerated subject matter jurisdictions, and that's where you have all this other stuff, right? Your controversies. This controversy here, this controversy here, between the states. There are 9 total. Once it falls into one of these categories, then you can find the proper remedy. Either in law applies to one of these 9 cases, or equity applies to one of these 9 cases. So this is a jurisdiction of remedy. This is a jurisdiction of remedy. And then we have one that's unique. This one here is the one that is unique. This is how it's listed here in Article 3. You have to explain it this way, or it doesn't make sense. To all cases of admiralty and maritime jurisdiction. This is its own jurisdiction. And these have merged into the Federal Rules of Civil Procedure and Criminal Procedure. Of course, these top 2 here apply to civil cases. This is where we get into criminal cases when it comes to admiralty. However, admiralty did merge into the civil procedures as well. I'm going to go over that now, and this is about 2 paragraphs long, so bear with me. I'm actually going to show you what I'm reading here in the fuller commentaries. This right here are the 2 paragraphs we're going to go over. So we can talk about criminal cases and a very brief history of admiralty and maritime. Okay, so prior to the year 1948, the federal criminal law did not have a separate procedural framework for maritime crimes, such as piracy or murder on the high seas, and their prosecution generally followed the federal criminal procedure of that time. The early versions of the Federal Rules of Criminal Procedure began with the Crimes Act of 1790. Then it was the Assimilative Crimes Act, which was in 1825, with later versions. Brings us up to the 1909 Criminal Code, and this was the primary federal criminal code before the 1948 revision. That revision is very important. Before we get to that, we have the Federal Rules of Criminal Procedure in 1946 that was first adopted by the U.S. Supreme Court. Now in 1948, this was a different event. 1948, those same Federal Rules of Criminal Procedure from 1946 went through a massive revision and codification of all federal crime statutes, where 18 U.S.C. 7, which defines the special maritime and territorial jurisdiction of the United States, was codified into the federal law at this time. Okay, so we have the year 1948 is when the Federal Rules of Criminal Procedure changed. This is when the revision happened, right? There was a big revision of the criminal code, and during this revision, Congress added in things of maritime jurisdiction. So right here, 18 U.S.C. subsection 7. I'm just going to show you that real quick so you can actually see it. When the Federal Rules of Criminal Procedure changed in 1948, this was added into the law. And now we all of a sudden have this special maritime and territorial jurisdiction in the United States. This does apply, right, to the sea. So this is commerce on the sea. We talked about commerce right here. This is Article 1, Section 8, Clause 3. This is the Commerce Clause. This is where Congress gets their power to regulate commerce with foreign nations and among these several states with the Indian tribes. So across state lines, we have interstate commerce. This is different than maritime commerce. This maritime commerce takes place on the seas. Part of this argument is that it's colorable in nature. All right, so we have a colorable version of this jurisdiction being plugged in to our federal rules of criminal and civil procedure. So essentially what happened is the U.S. Congress established a single unified procedural framework that applied to all federal crimes. This is when Maritime Admiralty merged into criminal cases. That's how it came about. Now, the civil history is smaller, so it won't take us long to explain. The U.S. Congress passed the Rule Enabling Act of 1934, is where our story begins in the civil world. This is codified in 28 U.S.C. 2072, which later created the Federal Rules of Civil Procedure in 1938. The Federal Rules of Civil Procedure abolished the separate common law and equity court dockets at the federal level, merging them into a single civil action. So those two merged together at this time. We have common law and equity cases merging into one civil action. Now all you got to do is go into the court and file civil action, and it can apply to either. The U.S. Supreme Court had previously ruled that there are no common law offenses against the United States. In these cases right here, we have United States versus Hudson and Goodwin. We got the United States versus Coolidge. We have the United States versus Britain, and the United States versus Eaton. They all confirm that there are no common law offenses against the United States. Boom. So we can pretty much write off common law, okay? It's merging with the statutes. That's just what happened. We can't stop it. Best thing we can do is kind of understand what happened. Historically, the Admiralty courts had distinct procedures, but in 1966, Admiralty procedures were merged into the Federal Rules of Civil Procedure as a civil action. That's when it merged, 1966. The Federal Rules of Civil Procedure, Rule 9H, under the notes of Advisory Committee on Rules, 1997 amendment, it says Rule 9H was added in 1996 with the unification of civil and admiralty procedure. I didn't believe this was a real thing. I couldn't believe it when I looked it up myself. I'd rather show it to you because if we're going in hard on admiralty, let's go in and check it out. Okay, so what we're doing is you have this here, right? Rule 9, special pleadings. We go down here to Section H. We now have Admiralty and Maritime claim. This has now been added in. I'm just going to leave this highlighted. Let's go to the top of the page. You can see we're still on Rule 9. We're scrolling down. Boom, we have H, Admiralty and Maritime claim. We're going to scroll down just a little bit more here into the notes. These are all notes. This note in particular, in 1997, Rule 9H was added in 1966 with the unification of civil and admiralty procedure. That was unified. It was merged into the civil procedures. That's how it came to be. Okay, so as we learn about this, and you're wondering how did the Admiralty courts actually go from Article 3 somehow into our Article 1 courts, it's colorable in nature. Now, colorable is a very interesting word. If we look in the Black's Law Dictionary, 6th edition, you're going to read that of a claim or action, it's appearing to be true, valid, or right. And the second definition is intended to deceive or counterfeit. So colorable means that it's appearing to be true. And we have the federal and state courts that are acting colorably, and we got to figure out why. And so we're starting to get to it. We've understood that the judicial power is a big part of the problem because they're posturing like they have this judicial power from Article 3, that somehow these lower courts are making these judgments and orders, and we think they're final, so we never appeal. But this is proven that the reason they're only given a legislative power and not judicial power is actually why you have the right to appeal. That's why it exists, is because their decision isn't final. And that's really the point of this, is I'm showing you that the lower branches of courts are only administrative in nature. They don't hold any real power. It's not a constitutional court. Only Article 3 courts that hold the judicial power of the United States are constitutional courts. And you only find those at the appellate level or the Supreme Court level. Never at the lower district level or the lower magistrate level. That's what you got to know about Admiralty. The federal power to regulate the transactions of the Social Security number is a part of a much larger nationwide commercial stream or functional network. We're talking about the commercial jurisdiction of Congress because they're expanding it in such a way. It's much like the navigable waters that are the functional domain of maritime commerce. That's the law of the sea. We're trying to not really talk about the law of the land, but we're talking about the law of transactions. That's what commerce is. And they're expanding this as maritime got added in to the civil and criminal procedures. The Commerce Clause of Article 1, Section 8, Clause 3 was expanded. Congress has the power to regulate commerce with foreign nations and among the several states. So that little section there in the District of Columbia, that 10 square miles, has now expanded because it's no longer transactions on the sea. It's transactions in the jurisdiction of the United States. And they're taking place in these types of courts, these tribunals that hold no judicial power. They have a legislative power. And they're trying to expand the Commerce Clause out of the District of Columbia and into your home. Well, into your Social Security number transactions. That's what they're really trying to do. They're expanding it all across the states in that way so they don't have to add a federal territory everywhere they're doing a transaction. Instead, it's the Social Security number, your Sam's Club card, and that you're using all over the place is what's giving them jurisdiction. So that's what we're trying to understand about this. And from a critical perspective, it could appear that the Commerce Clause's expansion into maritime areas is riding on the coattails of a very long established and unique federal jurisdiction called Admiralty, the law of the sea. It was already existing. It's like the Commerce Clause. Its power gained an aura of historical legitimacy in the maritime context because Admiralty was already there. Even if the Commerce Clause's direct application is new to many specific regulations, it was already there. Maritime and Admiralty's jurisdiction was, from its earliest days, intrinsically focused on the financial and commercial aspects of seaborne trade. This jurisdiction was notably pecuniary in nature, means it dealt with money, frequently involving creditor and debtor relationships, maritime liens. You can see how this is extremely similar to the commercial jurisdiction. They copied it, is what I'm telling you. When they added it into the federal rules of civil and criminal procedure, they altered everything by the revision of those codes. They altered everything to become more like maritime and admiralty jurisdiction. The commerce of the sea now became the commerce of all transactions on land. The commercial jurisdiction of the U.S. Congress, that's what we're going to call Article 1, Section 8, Clause 3. It's the commercial jurisdiction of Congress. This represents an evolution of the principles exemplified by maritime and admiralty jurisdiction. The Commerce Clause became the constitutional vehicle to extend federal regulatory power beyond the navigable waters of the ocean, creating a new domain. This commercial jurisdiction is a domain or sphere of transactions that is not physical land, but rather an artificial space tied to federal programs, your Social Security, and interstate commerce. The commercial jurisdiction under Article 1, Section 8, Clause 3 constitutes a condition of contract under the criminal aspects of a colorable admiralty jurisdiction. This is the argument we make in court. It constitutes a condition of contract. They had to pull you in through a contract into their jurisdiction and out of your state jurisdiction into their federal jurisdictions. And it applies under criminal aspects of a colorable Admiralty jurisdiction. That's what the commercial jurisdiction of Congress is. Article 1, Section 8, Clause 3 describes a colorable Admiralty jurisdiction. And we looked in Black's Law what colorable means. It means appearing to be true, but it's intended to deceive. The commercial jurisdiction constitutes a condition of contract under the criminal aspects of a colorable Admiralty jurisdiction. The jurisdiction is colorable because it is a remake of the old maritime system. It's just made new and expanding Congress's commercial jurisdiction. The overall problem, besides what I just told you, is that both the federal and state courts are acting colorably using legal tender instead of constitutional money. Now, what do I mean? You probably heard there ain't no money. Well, it's true. There ain't no money. No constitutional money. There's Federal Reserve notes, but it ain't constitutional money. If we look under Article 1, Section 10, we actually find the answer to what constitutional money is. You've probably wondered, no state shall make anything but gold and silver coin a tender of payment of debts. There it is. No state shall make anything but gold and silver coin a tender in payment of debts. Tender of payment is the umbrella term for all the other types of payments that exist. Legal tender, which are your Federal Reserve notes, is one option under the whole umbrella of categories that exists as tender of payment. Gold and silver is another form of tender of payment. So right there you have it. That's what real money is. It's gold and silver. That's constitutional money. In another video, I described what happened with gold. I described how they suspended the gold clause in 1933 domestically. Then in 1971, with the Nixon shock, they suspended the gold clause internationally. The original promise to pay was the transferability of the US dollar into gold. That was the original promise to pay. If we're talking about the national debt, the original promise to pay it back was to pay it back in gold and silver at a future date when it's reinstated. That's what the promise to pay is. Now, it was suspended because they're no longer allowing that to occur. They wanted to push this whole Federal Reserve system, so they had to get rid of the gold, the ability for you to do transactions in the private where there's no tax. They had to get rid of that so they could tax everything in your life. And this is how they did it, man. And I'm just giving you a brief synopsis of that. That other video will go so deep into this. I'm just touching on it. But the reason that it's colorable, that the jurisdiction of Congress is colorable, right, is also because they're using fake money. Fiat money. It's not real money. Real money is gold and silver. Article 1, Section 10 proves that. We don't need to confirm it anywhere else. That is a fact. Therefore, the U.S. Congress had to get the private citizens of all 50 states to agree to leave their jurisdiction from their state and come in to their colorable Admiralty commercial jurisdiction. This allows the commercial clause. The commercial clause allows the federal law to apply across all the 50 states without necessarily making every location of a transaction a federal territory. That's what I was trying to say. This next part's pretty important. The Judiciary Act of 1789 established the U.S. District Court system and structured the Supreme Court. It also structured the subject matter jurisdiction over the 9 categories of cases that you're going to find in Article 3, Section 2. Those cases can be heard on both the federal level and brought up to the Supreme Court level. They had to find a way to structure, well, what are these 9 cases? What are they about? They're just talked about in Article 3, Section 2. But they needed to know what they were actually about. So they have this Judiciary Act of 1789 to fill in the gaps. Now here's what my opinion is overall. I think this is what's going on. It appears that the Article 1 legislative courts are using the Judiciary Act of 1789 to masquerade behind a judicial power under Article 3, but it's artificially clothed under Article 3. It's pretending to be a constitutional court, and it's allowing these Article 1 judges to conduct their bench trials and jury trials at the lower level courts. That's what I think is happening. We're given the power to appeal all of their decisions. None of their decisions are final. And they're masquerading as though they have this constitutional judicial power under Article 3, but it's just a legislative power. That's what separation of powers was all about. The judicial branch never granted judicial power at all to the legislature. So it's a facade made of fear. Once you get into court, that's all you're up against is fear. Now the finale to this video is going to be 2 cases that absolutely prove this point. The difference between an Article 1 court and an Article 3 court. And those cases are foundational. They happened in the 1800s. And I got a little quote from each of them that we're going to talk about right now. And make sure that you write this down too, because these are what you're going to use, and you're going to reference these in your state courts. Because odds are you don't have some sort of case law that's this specific. So you're going to use them as reference points to this information when you talk about the colorable Admiralty jurisdiction of the commerce jurisdiction. So the first case is American Insurance Company versus Cantor. This is 26 U.S. 511. This took place in the year 1828. They go on to say the judges of the Superior Courts of Florida hold their offices for 4 years. These courts then are not constitutional courts in which the judicial powers conferred by the Constitution on the general government can be deposited. They are incapable of receiving it. They are legislative courts, created in virtue of a general right of sovereignty which exists in the government or in virtue of that clause, which enables Congress to make laws regulating the territories belonging to the United States. The jurisdiction with which they are invested is not a part of the judicial power, which is defined in Article 3 of the Constitution, but is conferred or granted by Congress in the exercise of its powers under the territories of the United States. You can see this case law right here describes everything I just explained to you in one paragraph. It's beautifully written. That's American Insurance Company versus Cantor, 26 U.S. 511 of the year 1828. The next case law that describes this as well is Propeller Genesee Chief et al. Versus Fitzhugh et al. 53 U.S. 443 took place in the year 1851. This case goes on to say, this power is an extensive upon the land as upon water. The Constitution makes no distinction with that respect, and if the Admiralty jurisdiction in matters of contract or tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power of regulating commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. And it may embrace also the vehicles and persons engaged in carrying on it. It would be in the power of the passengers or merchandise from one state to another and over the persons engaged in conducting them, and deny to the parties the trial by jury. Now, the judicial power in cases of Admiralty and Maritime jurisdiction has never been supposed to extend to contracts on land and to be executed on land. But if the power of regulating commerce can be made on the foundation of the jurisdiction in its courts, and a new and extended Admiralty jurisdiction beyond its hereafter known and admits limits may be created on water under the authority, the same reason would justify the same exercise of power on land. What a mouthful, but how wonderful is that? That describes going from the law of the sea onto land through these transactions. I'm telling you, it's transactions used through the Social Security number, which was also a federal identifier created by the U.S. Congress. It was done through the Social Security Act of 1935, I believe. But that act passed and created the Social Security Administration, who then created the Social Security number. Okay, so that's how it's all tailored to these transactions that they own under the legislative branch. They are in charge of this. They have plenary power. And these are the two cases that are going to help you on your state level when you're trying to make these arguments that this is a colorable Admiralty jurisdiction. It's a commercial jurisdiction of the legislative branch, and they do not have judicial power under Article 3. And the only proper way to actually challenge jurisdiction is through the Sixth Amendment. Don't just say you challenge jurisdiction. You're going to lose. You need to make a constitutional argument in these criminal cases, and you have the right to be informed of the nature and cause of the accusation, and they have the duty to inform you. The nature is commercial. It's commercial in nature, and it applies to the transactions on the land colorably. So I hope you enjoyed this video. I wanted to give you a huge overview of what's happening here in the separation of powers doctrine, and as well as how Admiralty was sort of infused or incorporated into our federal rules of criminal and civil procedure. That's how they did it. That's how it came to be. And this is how all the confusion is explained. Be sure to subscribe to the channel and activate that notification bell if you're trying to learn more about the law. See you in the next one.